Joining us now to talk about this high-profile case is defense attorney Brian Watkins. Brian, thanks for joining us again right here on The Floor. We appreciate your time.
Hey, thanks for having me.
Day 9, and we understand that this is the last witness that the prosecution has brought on the stand today. It was a deputy district attorney who went through various search warrants and brought out a lot of evidence that we have not heard up until today, last day, day 9. What was your thought on their tactics with that?
You know, they did save that for the end. I don't know why they saved it for the end, but the question here is they brought on a lot of evidence that shows a collapsing and a failed marriage. But showing and proving a failed marriage doesn't prove murder. And that's the key here is, do you have enough evidence to make Mr. Millete stand trial for murder? Not for being a bad husband or anything like that, not for being involved in a collapsed marriage. Not even infidelity proves murder.
And let's talk about that and sort of unpack that for a moment here, because what the judge is looking for to hold him over for trial is very different than what a jury will be looking for at a trial in order to convict him of murder. Maya has never been found. There have been no remains found. What happens next as far as if this in fact goes to trial? Is there enough evidence in your opinion?
You know, the question is, you know, they don't have a body. So what was the cause of death? That's always what's going to be missing when you don't have a body for the prosecution. And again, like the prosecution proving a collapsed marriage, proving motive to commit murder doesn't actually prove murder. Now, in a preliminary hearing, the standard is quite low. It's a preponderance of the evidence. So at this point, only thing the judge has to do is think, is there enough evidence to think that he did it? That will get him bound over and stand trial. But at a trial, the jury must find guilt beyond any reasonable doubt. So that means they have to know beyond any reasonable doubt that he did it. So the standards are very different. So the case most likely will proceed to trial based on the evidence presented at the preliminary hearing, but whether or not he'll be convicted, of course, is going to be another story.
Brian, you're a defense attorney. What do you think of the defense's tactics in this preliminary hearing? You
know, the defense really didn't show its hand, and that's normally what happens in a preliminary hearing. You want to look at the prosecution's hand while not showing your hand. And in this case, the defense did not put on any evidence. So they didn't explain any of these things that the prosecution was presenting. Now, at a trial, you can expect to have a lot of those things explained. So here it's kind of one-sided. So clearly the prosecution was just putting on all of its evidence. And of course, the defense is going to use that when they create their trial, when their case at trial.
If the judge does go ahead and hold him over for trial, what happens next as far as the timeline of all this? When could we expect that decision to be made? And again, if there is enough to hold him over for trial, are we looking at a year down the line?
Well, no, that's going to depend. You know, the case will most likely be headed for trial. They will set dates right after this preliminary hearing on when the trial will begin. However, will that date be moved and continued? Yes, it will, as investigation continues to unfold. And of course, the defense wants to investigate everything that they just witnessed that the prosecution put on. They want to try the prosecution's case. They want to test it. They want to see where they can poke holes in the prosecution's case. And that may take some time. Months. 6 months.
It could be that long, if not perhaps even longer.
Yeah.
Let's talk about for a moment, if this does in fact go to trial, and again, we're waiting for the judge to make that decision once this hearing wraps up. Do you think it'll stay here in San Diego County, or do you think because of the highly publicized nature of this case, it could perhaps be moved out?
Not nowadays. We're not going to move any, they're not going to move any trials. Why? Because everywhere it gets publicized. There's no caves that anybody hasn't heard about this. With social media today, the media the way it is, the bottom line is information gets disseminated, and there's not going to be a place that hadn't heard about this case. So there's really no use in moving it from San Diego County.
Defense attorney Brian Watkins, we do appreciate your time. Day 9 of the Larry Millete preliminary hearing. Again, the final witness on the stand, and we'll keep everybody updated as far as what happens today and going forward. Brian, thanks.
Hey, thank you.